Welcome to today's program titled Turning Informal Government Outreach into Effective Internal Investigations, the fifth session of our Winning Combinations webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Erica Bakes. Erica, you may begin.
Thank you, Sadie. Okay, so welcome to our webinar series, our micro webinar series, Winning Combinations, which is where we pair a Cypher government contracts attorney with another lawyer in another practice area at our firm, and we talk about an issue that intersects both practices. Our thought is that your legal issues don't always fall neatly into one practice group, so the content that we provide you shouldn't either. So for this installment in our series, we are discussing how to handle informal government outreach. I'm Erica Bakes. I'm a partner in Cypher's Government Contracts Group. My practice includes compliance, internal investigations, and bid protests with a focus on national security issues such as classified contract compliance, access restricted information like CUI, and export controlled information, as well as supply chain security. I'm thrilled to be joined by Rich Marvillo from our White Collar Practice Group. Rich has decades of experience in high-profile white-collar investigations on a variety of topics, including the False Claims Act. And while it's not always under the best circumstances I have to call Rich, he is always fantastic to work with. So thank you so much for being with us today, Rich.
Thank you, Erica.
So before we jump in, I want to plug our next session. On February 19th, I will be joined by our employment group's Rachel C. Rachel and I will be discussing federal government procurement of AI. We'll either be talking about what new direction the Trump administration has taken with respect to AI requirements, or we'll be talking about the ones that Biden has implemented. Rachel has significant experience on the government side, buying technology, including AI, so it'll definitely be an interesting conversation. Okay, so let's turn to today's program. We've got 5 main topics we want to hit on. First, how government investigations start, what to do when you receive a voluntary request or a subpoena, how to identify the scope of your review, what it looks like to start an internal investigation, and then finally, we'll talk about maintaining privilege in an investigation when you're dealing with the government on the other side. So if you have any questions, as Sadie said, please feel free to pop them in the chat. If we don't get to it, we'll be sure to email you after. So let's get started and jump right in. Rich, in your experience, how does a government investigation typically start?
Well, the word typically is a strange one to be applying to a government investigation. They start for all different and varied reasons. The principal way in which many of them start is through an anonymous tip, whether it's under a whistleblower program or not. The government gets thousands of tips every year about possible violations of the law. They're also a good source for one another. Government agencies will communicate with one another and provide information to another government agency suggesting that investigation is warranted. For example, the SEC and the FTC will typically call the Department of Justice when they believe that their laws are being violated criminally. Another means by which investigations start is through routine inspections and examinations. Those of you in the government contract business know them well. Oftentimes, an inspection will start and the inspectors will find something that indicates that there may be a problem with compliance with the law, and they'll refer that matter to the enforcement department of their particular agency, and the next thing you know, you'll be stuck with an investigation. There are also industry sweeps. You may have read either today or yesterday, I can't remember, about the SEC bringing a case against a variety of broker-dealers for offline communication using WhatsApp. That started out as an industry sweep looking into common practices within the industry. Newspaper articles and media are also a source. I remember, showing my age, I remember back in 1978, an employee of a very large company jumped out of an office window. And that started what's known as the Foreign Corrupt Practices Act, because what he was doing was concealing the fact that there had been bribery that had gone on. News of a stock drop or a stock pop, when the stock of a company moves irrationally for no apparent reason, the government will look. Same with regard to aberrational trading. So, for example, an announcement by a government contractor of a large government contract that is preceded by trading will generally kick off an insider trading investigation by the Department of Justice. In addition, resignations of senior personnel have led to investigations. CFOs resigning oftentimes are followed by accounting investigations, and there have been a lot of publicity about certain senior CEOs who left the business, to be followed by sexual harassment investigations. And last, don't forget about your favorite plaintiffs' lawyers. They will get publicity out of their lawsuit and oftentimes will try to get the government to sign on to their side of the lawsuit.
Yeah, so really a variety of ways here. I think in our my experience, we're typically dealing with whistleblowers, but you're right, there does seem to be a variety of when these questionable circumstances come up, do we need to look closer, even from a government side when there's not a whistleblower? So Rich, you mentioned industry sweeps. When the government approaches a company on an informal basis and asks for information, such as in an industry sweep, what should the contractors do in that situation?
Sure. Be thankful, actually, that the investigation is informal at the moment. You want to keep the investigation informal for as long as possible. There are several reasons for that. First, without subpoena power, there won't be any testimony under oath, and the documents that you turn over will be turned over voluntarily. It's not to minimize the burden on a voluntary production, but it's nice not to be dealing with subpoenas and subpoena enforcement actions. Secondly, the people who are conducting the investigation are not fully invested in a matter when it's an informal inquiry. They haven't yet decided whether there's a basis for which to bring in an enforcement matter, and they're apt to deal with other priorities on their schedules. And so, with any luck, you may lose the battle of popularity. Thirdly, senior management in the enforcement divisions of various agencies pay more attention to formal investigations. They monitor them more closely. They expect certain timetables to be followed with regard to investigations. And so people are paying more attention to you. So keep it informal if you can, so you don't have to respond to subpoenas or even civil investigative demands. What you want to do is get the request in writing. Sometimes a government official will just pick up the phone and say, hey, I'd like all the documents to relate to the XYZ transaction. You want to get it in writing so that there's no ambiguity as to what it is that the government has requested. Generally speaking, you want to have counsel contact the investigator to try to ascertain what he or she can about the scope of the investigation and the company's role in it. In a government investigation of federal criminal activity, for example, there are targets, subjects, and witnesses. That's not true with regard to administrative agency investigations, at least according to the administrative agency. The reality is that they have targets, and you want to have a sense as to where you fit into the scheme of things. So you'll have counsel try to reach out and talk with the investigator. Junior investigators are loath to talk. They worry that they're going to give something away. The more seasoned investigators are happy to talk a little bit with you. You won't get much information, but you'll get some kind of investigation, which will give you a sense of where the investigation is likely to head. You want to negotiate the breadth of the request and the timetables. Just because they ask for everything under the sun doesn't mean you need to give them everything under the sun. It's important to manage the government's expectations as to what it is you can produce and when it is you can produce it. Sometimes the government will insist on an immediate production, and you can deal with that by agreeing to a rolling production where the things that are most accessible get produced more quickly than the other things. Don't overpromise. I've been in too many situations where Eric and I had one where a company didn't fully appreciate the difficulties it would encounter in producing emails and the like, and promised to produce documents on an expedited schedule, only to have to go back to the government and ask for extensions. When you continue to ask the government for extensions, they think you're not cooperating and that you're trying to delay the investigation. So don't overpromise. Manage expectations and then try to meet those. It's very important that you distribute a document hold memorandum. Now, I'm not suggesting that you send an email to 3,000 employees of the company saying, hey, we're being investigated, hold on to your documents. But you've got to tailor your demand notification, your document retention notification to your particular company and to who's likely to have responsive documents. You do not want to have to explain to the government why a particular document that may be relevant got destroyed. So make sure you involve the electronic discovery aspects and the IT department. As you know, emails and the like are automatically deleted under document retention. Unless you intervene, you're going to wind up losing documentation that the government's going to be quite upset about.
Yeah, Rich, I did have a question on this. I've worked with a company who dealt with an industry sweep who actually had like very serious concerns about kind of how much this would cost because they needed to engage the outside counsel. The inquiry, they even had to do an interview and prepare witnesses in response to that industry sweep. And it cost them a lot of money when they weren't the target of any sort of investigation. It was for broad restructuring of how the industry worked from a government regulatory perspective. In your experience, is there negotiating room to kind of say, look, we're undergoing a transaction right now. We're doing an IPO right now. We don't have the resources internally to support this. Are government investigators sympathetic to kind of excuses like that?
Generally not. You can, if you get you're starting a relationship with another lawyer or an investigator that you're going to live with for a period of time. So the kind of relationship you develop with them will be indicative of the kind of breaks that you're going to be able to get. You'll find some investigators are sympathetic with those kinds of discussions, but by and large, the government believes that investigations are the cost of doing business. You may be able to tailor the document request to your particular company, but in an industry sweep and the like, it's more often than not that you're going to wind up producing all the documents that everybody else produced.
Yeah, that makes a lot of sense. So when we're dealing with a voluntary request or even a subpoena, are the production protocols the same as in what we would see in civil litigation?
They're similar to what you would do with regard to a Rule 34 request, but the consequences of non-compliance with a government request are so much more significant that you've got to use all reasonable efforts to try to provide all the documents. In fact, with a subpoena, you may have an executive officer asked to certify that the compliance was complete. Again, the point of view being you'd like to continue the document requests as voluntary requests as opposed to subpoenas. The more responsive you can be, the more slack you're going to get. So you'll need to identify all the custodians, not just the people who are likely to have the most relevant information. Don't depend on your employees to identify the documents that are relevant. One horror story I can give you is a large company had its legal department ask its employees to produce documents that were relevant to a subpoena that they got from a government agency. People cooperated with that, but one individual neglected to turn over notebook he had on his shelf of notes that he had taken, and he wound up having to hire his own lawyer to represent him in an obstruction of justice investigation. So get the legal department involved in helping employees understand the scope of the subpoena and what's responsive. One of the more important things you got to do is withhold documents that are privileged. I don't care if it's an inspection or what basis it is. The government does not have a right to privileged documents. It doesn't have a right to ask for privileged documents. So make sure that you are withholding privileged documents. If the entire document is privileged, withhold the entire document. If only a portion of the document is privileged, then redact the non-privileged portions. Redact the privileged portions and produce the rest of the document.
Yeah, that makes a lot of sense. I think on the production part, in our experience, we're typically dealing with, electronic communications, electronic documents. We're working closely with an IT team on the client side, and then we have our discovery team on our side. And we're working, looking through initial documents to identify custodians, not just relying on what people have told us about who's involved. Identifying the location of documents, what shared drives are involved, to your point, what paper documents are involved, where do we need to look for these things. I think that there's, in certain instances, it may be appropriate to image computers or image phones, especially where employees are using their own phones or their own computers, or they're communicating via those devices with parties that are also related to the investigation. Search terms are also going to be extremely important. Starting a running list and then adding to it as you go on is my best experience in that case. Rich and I, in our recent investigation, worked with the government to get buy-in on those search terms, which was really helpful to allow them not only to give us insight into what they were looking for, but to also to help us make sure that we had everything we were getting and making sure they were responsive to the requests from the government we were receiving. And then finally, I think that this is like pretty, time consuming to do these electronic reviews and document collection, especially. So make sure you're giving yourself enough time. Make sure that you're identifying multiple avenues to collect these documents in the event that one may be faster than another. And especially consider, as Rich was saying, your deadlines in responsiveness to the subpoena, especially, or the informal request. Oftentimes government agencies will have kind of internal deadlines they need to meet. Other times, especially when it's an informal investigation, they're okay dragging their feet on it. So it also just depends on what they're looking for. Rich, I did want to ask you one other question on this particular topic. How often are you finding it helpful to go and be on site to look at various things? I think when we're dealing from our side, when we're dealing with a manufacturer, oftentimes it can be helpful to go to the site and get a better understanding of how these employees are interacting, what their, what their situation looks like, as well as, are there, specifications that are printed and in folders on desktops? Are there, what's in the shop? What does the shop look like? In your experience, when are boots on the ground kind of more important?
Well, it depends on the kind of inspection that you're referring to. It's absolutely important. In the typical case where you're just dealing with a document subpoena that's asking for a broad variety of records with regard to a host of transactions, it's less important, as long as you are communicating with the right people, and in particular the IT people who have become indispensable to the process. So I don't generally make a practice of going to visit companies that were complying with their subpoenas. It depends on the industry too. In the regulated industries like the broker dealer or the investment advisor industry, which are subject to inspections, you may want to wind up spending some time understanding the lay of the land.
Yeah, that makes total sense. So just to keep going, we wanted to talk about how kind of these agencies, they have these broad investigation powers over certain industries, and especially in the government contract context. Sometimes they announce they're coming, sometimes they don't. So what do you do? What should a company be thinking about when they show up, when these investigators show up at their door?
Well, it's going to depend to some extent on what the authority that the agency has, and they vary across the board, as you say. And there are some agencies that have statutory right to inspect all books and records at any time they want. The most important part is to have a plan. And if you don't have one, you should develop it now before they are knocking on the door. That plan should take into account the statutory authority that particular agency has, so you have an understanding as to what they can look at and what's beyond the scope. And then you want to plug for counsel. I guess you want to contact counsel, but equally important, you want to contact the senior people in the company to organize a response to the inspection. You want to try to get what they want in writing. I had a situation about a month and a half ago where some inspectors from a particular government agency came in and they wrote little scrap paper notes to the company about what documents they wanted without regard to time frame or the like. And so we wound up writing a letter to the government agency saying, this is what you asked for, so that there would be a record of what it is that we asked for, and there wouldn't be any what they asked for, and there wouldn't be any question about whether we complied. You want to maintain at all costs calm among your employees. We don't need heroes during a government inspection. The best way to ensure that you're maintaining calm is to prepare your employees with the plan for what to expect in advance. It's perfectly appropriate and warranted for you to document communications that you have with the government agents. Not only the requests, but whatever comments they make, snide or otherwise, in connection with their visit. And it's important for you to memorialize the responses that they get. You want, where possible, you want to have one person responding to the government so that you speak with one voice and that you don't give conflicting explanations that need to be explained away later. They'll press you for documents. Some will come in and say, we want these documents immediately. We won't leave without them. That's okay. I mean, if to the extent that you can get readily accessible documents available to produce them, there's no problem in doing that, provided you do it in a rational way. But if you need time, you have to be able to ask for that time. And most government investigators will be sympathetic with the need to pull documents over the course of 24, 48 hours or longer. Again, protect your privileged documents. One way to do that is to segregate them. The legal department generally is in a different space than operations, which is helpful, but privileged documents get intermixed in files. So it's appropriate to ensure that your documents are marked attorney-client privilege or attorney-work product, to ensure that if an investigator stumbles on a document, that he or she knows that he or she shouldn't look at it. Where it's possible, and it's not always possible, you want to limit the interviews to the existence and location of the documents that they've requested. In a situation such as Erica pointed out, or in other kinds of inspections, it's not going to be possible to avoid answering questions. And again, you want to make sure you have the right person, particularly a knowledgeable person who's answering the questions. Get that person an opportunity to meet with counsel before the interview if possible. And generally speaking, you'll succeed if you ask the inspector to have counsel present for the interview. What you don't want to do is destroy, alter, or remove any documents. You don't want to lie to the government, because it's a crime whether you're under oath or you're not. You don't want to consent to a broader search than is absolutely necessary under the circumstances. And you don't want to volunteer substantive information about the transaction or events that are under investigation.
Yeah, I think that's right. And I think, we've gotten a lot of requests, especially the past couple of years, to put together actual plans of a government investigator or a policy, a government investigator shows up at your door, and here's the policy on exactly who you're calling, when you're calling them, and the extent of it. And I think that, beyond just like investigations that we're talking about, where, you and I would be involved from a government contracts or even a security standpoint, I had a client who had an employee who had the FBI raid the employee's home for child pornography charges. And then the FBI showed up at the client site asking for that employee's computers and things like that, because they wanted to look at all of the IT devices that the employee had. And so even where there's nothing to do with the company in that circumstance, they just kind of got involved as a result of this person being their employee. Having a plan in place where you know who to call, has all of these kind of tips and tricks that Rich has given, I think is really important. Rich, in your experience, are you seeing an uptick in those policies and procedures as well?
Yes.
Yeah, definitely. Okay, so let's say the government's investigating, we know they are, at what point are we pulling the trigger on an internal investigation?
Early on. It really depends on what you mean by an internal investigation. Every defense of every government investigation involves, to some extent, lawyers for the defense coming in and digging into the facts to try to understand what happened. What we're talking about here is a more nuanced term of a systematic review of documents and interviews of witnesses to uncover possible violations of law or violations of company policy. That's usually conducted by counsel under the cloak of privilege. So it's not a fact-finding investigation per se. And the organic documents that you utilize to conduct that internal investigation should be clear that it is being done for the purpose of seeking legal advice. It has a purpose beyond, as I just said, beyond getting the facts for the defense, but it's going to produce facts that you're stuck with forever. And so you'll have to find your defenses legal and factual in the information that you develop. So when you scope out your plan of investigation, ensure that it's broad enough to be able to uncover the good and the bad. It is the basic means of discovering whether or not there has been a possible violation of law, the scope of that problem, who's responsible for it, and importantly, how to stop it. It is a means by which you take remedial action to ensure that you're going to mitigate your damages. For example, if you discover there's a defective product on the shelves, you don't want to wait for the government to tell you to pull the product. You want to pull the product on your own. And you will get credit for doing that with the government when they get around to assessing the culpability of the institution. They will take into account the remedial steps that the government took. In some cases, you can even convince the government to stand down while you do your internal investigation. Highly recommend that you talk to the government about what you're going to do and see if you can't get them to stand firm while you're doing your investigation. The price you usually have to pay for that is to agree to turn over the results of the investigation, but time permitting, we'll talk about that for a few seconds.
Yeah. Okay. So who, Rich, in your experience, should oversee the internal investigation from a company standpoint?
Well, generally speaking, the general counsel's office can, because all kinds of investigations happen, and the legal department can do it. When you've got management involved, you got an interesting situation where the general counsel is essentially investigating his or her boss, and that's problematic. So in those kinds of circumstances, you want to bring in the board of directors, or if the board of directors is comprised largely of inside directors, you want to create a special committee of outside directors to oversee the investigation.
Yeah, that's been we've run into a couple investigations in the past couple of years where we've had to do that. And it ends up working out quite well because they want you to be independent, which helps give you the freedom to, say things kind of bluntly, in my experience, in order to get an effective result. Okay, so and then who should conduct the internal investigation?
Generally, the legal department, though that varies too. Some companies involve their compliance personnel in investigations, and that's dangerous because compliance people generally don't enjoy privilege. And so if you're going to ask your compliance personnel to join in an investigation, make sure they're assigned to the legal department. In a case involving some significance, complex investigation, a complex investigation involving management, you probably want to go to outside counsel, experienced in conducting investigations. And whether or not that's your regular outside counsel or independent counsel will again vary with the extent to which management is involved, or a bet the company ranch kind of case where the issue is going to be who's got the greatest credibility in the eyes of the government or in the eyes of the public to be able to render impartial advice. So you will see sometimes former attorneys general of the United States or of the states are brought in because they've got the reputation. If you get a government employee to sit down and talk to you honestly, they'll tell you it matters less to them whether the investigation is independent. What matters more is the reputation of the counsel involved. Are they straight shooters? Are they going to tell them the truth regardless of whether they're independent or not? But it is helpful to have independent counsel who has not done a lot of work for a company or isn't familiar with management do those investigations that are going to get a lot of publicity.
Yeah, Rich, I think for both of us, we're kind of the I want to say, subject matter experts on, well, you're investigating a GovCon expert, let me help you with that. You're I know how to do criminal, I'm the white collar criminal attorney, like I understand it from that angle. And so creating these multidisciplinary teams especially is important. And Sadie is putting up our CLE credit because because we are at time. The code, if you are on the phone for the CLE credit, is SS1219. Again, that's SS1219. We are at time. Rich and I had more to talk about, but these half-hour sessions go by so quickly. I'd love to invite Rich back because I found this incredibly fascinating, and we've already had the materials prepped. So, Rich, thank you so much for your time. I really appreciate it. This was great, and I look forward to doing another one with you.
I'm happy to do it. Thank you, Erica.
Thank
Thank
you.
you, everybody.